We're on?
Yeah, it's been a minute. We're back. We've had a lot of court ourselves
And holiday.
and holiday, so happy holiday to everybody. We are here to talk a little bit about the Young Thug, Young Slime Life RICO case that just kicked off after, like, what was it, 10 or 11 months of jury selection. Finally, a jury was seated, and the indictment, which I believe took 4 hours to read, was read to the jurors. I understand there's a number of alternates because this case is estimated to take an additional, I think, 8 to 10 months.
So, just
So,
as an introduction, this is the Law Project, and I'm Daniel Kane, and this is Rachel Kaufman, and Rachel's the real star of the show. And
not
we
really.
set this Law Project up to discuss primarily, we wanted to do trials, and the first one we decided was the Young Thug trial. So both of us agreed that we wouldn't take defendants in the Thug trial. And then along came the Donald Trump trial, which is forthcoming, and neither of us took clients in that case also. So we're able to discuss these cases with you from a legal perspective. Both of us have pretty extensive legal background and have participated in trials similar. I think I may have done the first RICO case in the state of Georgia, which will tell you how old I am. And we're also going to comment on the judge, the lawyers, and the evidence. So
yeah, so we've had several cases against the lead DA, ADA in the case, Adrienne Love. So we have some personal experiences and comments about her. And then also I've tried several cases in front of Judge Glanville. So we know a little bit more about him.
Yes, and we know all the defense lawyers and have a very good understanding of criminal law procedure. So we're going to talk a lot about that. So just as an overview, this is Jeffrey Williams. He's the recording artist known as Young Thug. He's accused of having a street gang called what? YSL.
Yeah, Young Slime Life.
Young Slime Life, and it's accused, it meaning the organization, Young Slime Life YSL, is accused of committing 182 predicate criminal acts in violation of the Georgia RICO statute. The case started out with, I believe, 28 co-defendants. Many of them entered guilty pleas. Others were severed out for various reasons. And now the trial has commenced with opening statements. So with that, we'd like to talk about the opening statements.
So we should say that there's only six defendants left that are being tried during this jury trial. So
Yes.
there's six defendants. There's probably 12 attorneys there because they have several people coming in and out. But yeah, so there's only six left. We're expecting that several of the co-defendants who did take pleas, as part of their plea, they agreed to testify truthfully at this trial. So I expect a number of individuals that were co-conspirators, that were indicted and considered co-conspirators, will be coming in. How supportive they are of the state's position, time will tell. But the only thing that we're really going to talk about today are opening statements.
Well, but let me just, before we jump over to that, let me just say this. So there's a concept called allocution, and that's where you enter a guilty plea. And as Rachel said, several of the co-defendants entered guilty pleas. They entered guilty pleas to RICO, which means that they acknowledged that there was a street gang and that it had a name of YSL and that they were members. Now, it's very important to note that being a member of a gang and being a member of a street gang is not a criminal violation. You must couple that with illegal activity, a number of predicate acts. So these defendants who pled guilty, their guilty plea, their allocution was recorded by a court reporter. So they may be hesitant to testify at trial, but their recorded plea will be used to impeach them when they're called in to be witnesses for the state if they refuse to testify. They no longer have a Fifth Amendment right.
Well, to be clear, also, just another thing that I think will come up is that a lot of them were given ridiculously good deals that you couldn't pass up if you were guilty or not guilty. You would just have to take it to avoid the risk of what could happen at trial.
To get out of jail,
To get out of jail. I mean, anybody would take that deal if they would have offered it to any of the other ones. So it almost feels like I don't really care what they say at this point.
Yeah, which happens. Can I get probation, Mr. Kane? Yes, okay, I'll cop a plea.
Yeah, why would you be willing, Adrienne Love and Fulton County DA's office, to give these people, these gang members, as they call them, these violent gang members who, create a crater. I think she used the word crater during her opening statement, a crater in the Cleveland Avenue neighborhood. Why some of them should get probation and some of them should, be convicted of all these things and sent to prison for the rest of their lives.
So watch out. So this will be forthcoming. They'll get called in as witnesses, and we're just trying to alert you that they'll probably not want to testify and try to plead the Fifth Amendment and be reluctant to say anything. But then they have this transcript of their plea, which the prosecutors very well were aware that they can use to impeach them at the time of trial.
But they're not. But in that allocution, I don't believe that any of them provided additional information about the remaining co-defendants. So I don't really care what again, as a defense attorney, my argument there is, okay, they pled guilty. It was in their best interest. Their attorney advised them to do it. They never asked me what my story was then.
At the allocution, but they may have been debriefed by the state. But let's go to the bigger picture. We'll give an overview of what's going on now. And that is, as Rachel said, the jury has now been sworn in, and the court allowed the attorneys, as it must, to give opening statements, and the state has the burden of proof. The state's lead counsel is Miss Adrienne Love, and the state went forward, and after the state, Miss Love finished her opening statement, the defendants' counsels gave their opening statement. So Rachel will talk a little bit about Adrienne Love's opening statement.
Well, okay.
And what's appropriate and what's completely inappropriate.
So for an opening statement, you're supposed to be giving the jury a preview, an overview of the evidence and what it's going to show. So it's not a time to, be raising hell and arguing to the jury that your client is not guilty. It's just to say evidence is going to show that this is the story. This is what it's not going to show. That's really what it should be limited to. But oftentimes, as attorneys do, we're not great at following directions. So a lot of times attorneys do a lot of arguing. Argument is not appropriate during opening statement. That said...
So say that again.
Well, yeah. So what's appropriate doesn't really matter because it's what you can get away with, and that's sort of what we're going to talk about going forward.
All right, but there's a time for argument. It's a stage of the trial.
It's after all of the evidence has come in, and you do a summation to the jury, an argument of what the evidence showed.
That appears, the dynamics are the same as an opening statement where the lawyer stands up in front of the jury and in an opening statement gives a roadmap of what the evidence, and that's the key word, what the facts will show. In a summation or closing argument, you just argue. So talk about how opening statements got a little mixed up here.
Okay. So my understanding is that before opening statements occurred, in order to avoid unnecessary pauses for the jurors who are going to be listening to a lot of different opening statements, the judge wanted all of the parties, meaning the state and the six defendants, to turn over whatever demonstratives they were planning on showing, PowerPoints, anything they were planning on showing during opening statement. Because again, evidence hasn't even opened yet, which means that nothing is in evidence. So what you're showing the jury during your opening has to be appropriate. Okay?
And it has to be true.
And
that's an ethical obligation.
So the judge says, everybody turn everything over. Adrienne Love gets going in her opening statement. I want to talk about what she starts with. And then we have an issue with her not turning over what she was going to present to the jurors, which was in violation of the court's order. We're going to get to that. Adrienne Love, I wrote this down because I couldn't believe my ears. Adrienne Love stood in front of the jurors and she said, "This is the law of the jungle." That was her first interaction. That was
Wildly
her first interaction with the jurors. This is the law of the jungle. Then she continues into what I was confused. I was confused. I think you were confused. I was like, "Is this the Bible?" Because I'm not so aware of all the.
I was shocked that she said this is the law of the jungle. And just be mindful, you're talking about 6 African American co-defendants, so there's buzzwords that you just don't use.
Well, she went from the jungle to this whole thing about a wolf. Like I know a lot of things, and I don't believe that there are wolves in the jungle. They might be other places, but maybe lion in the jungle, tiger. But anyways, bottom line is she goes into this whole what sounded like Bible verses, but it wasn't the Bible. It's a story written about, I guess, a wolf, and she was
in a child's book.
In a children's book, but it's basically saying that they shall die. I mean, she was saying it was a very bizarre start. Didn't explain that she was quoting anyone as she was saying it. So we're looking at each other like, what is happening? The jurors are probably just trying to keep up because they know they're going to be listening to a lot of different stories. But they're like, is this the story? Anyways.
And is this facts in evidence in the case that you're going to present? So it had nothing to do with the case.
I just felt confused. So kind of a strange start. But a pretty, it's clear that she feels she has a visceral reaction to this idea that there's this gang, and she's saying she uses a lot of descriptors, not a lot of what the evidence will show, but she's talking about how this group of men, even though they're supposed to be individuals and their innocence, they need to be individually considered. She spends like the first 15 minutes of her argument talking just generally about how these people...
So you're calling it an argument because it was an argument. It was supposed to be an opening statement.
It was an argument. She's saying these people created they sucked children. These were her words. They sucked children into a crater in the Cleveland Avenue neighborhood of Atlanta. So she's talking like that. Then she goes, sucking children into a crater. There isn't... To be clear, the crater is she's using that as an analogy, as a metaphor, but she's not really explaining that. And then she just sort of goes into all these different gangs that, again, she may know a lot about it, but these jurors are just learning about it for the first time. And so I hear YSL, Rock Crew, Sex, Money, Murder, Bloods, and she's just saying crime, they commit crimes, they're bad people, crimes, blah, blah, blah. All begins with Rock Crew. All begins with the gang, not individually even discussing any of the defendants.
So let me hit the pause here for a second. There's a theory in prosecution. Feds use it a lot in their conspiracy cases. It's used almost always in these complicated cases where the theory of prosecution is throw as much mud at the wall as you can, throw as much egg on the face as you can, and hope that it sticks. So that at the end of the trial, the jury is going to say, well, I've heard so much incriminating information
about all these people
about
that they
all
must be
these
guilty.
People that they must be guilty. And we're going to dovetail into Jay Ott's opening statement in a minute, where he went in very specifically and addressed the specifics of his client's allegations against him. But the theory, just be aware, just be conscious that what Adrian did with these 180 some predicate acts was just started throwing the mud and then condemning people because of their upbringing and members of a wolf pack and drawing young children into a life of crime, which is really inappropriate for an opening statement. If it's her summation, go with it, rock on. But for an opening statement, she's just supposed to lay out the evidence.
And so what she's doing is explaining what she considers to be a gang and the general things that they did wrong. So I'm like listening. I'm like, so what are we talking about? Any of the defendants in this case? She starts mentioning Jeffrey Williams, who's Young Thug, but she's really not talking about any specific incidents. Because I'm like, so the jurors look. What is the evidence going to show? And it's going to show that a group of people, an entity that she's calling YSL, did all these things. Okay, at one point, Adrian, this is where my I couldn't believe she did this. I couldn't believe it, but I could.
Okay,
I could.
Well, hold on a second and tell them a little bit about, or I'll say a little bit about Adrian.
Please do.
Adrian is a senior prosecuting district attorney in Fulton County. I have tried cases with against Adrian. I have a lot of respect for her ability. Adrian Love is a very competent, very smart, very articulate prosecuting attorney. And she has one gleaming flaw. And I don't know about one, but She got a very pronounced flaw that we have seen already in opening statement, and you will see, I suspect you will see repeatedly through the trial.
Okay.
So talk a little bit about it.
So just having had many cases with her before, Adrian Love is I'm being careful. Adrienne Love is somebody who will do really whatever it takes to win.
To get the W.
And that's she was trained, and she spent most of her career, my understanding, is in an office under DA Paul Howard, who didn't reward, ethical prosecution. He rewarded wins. And Adrienne became...
And chastised losses.
Yeah, and so she became very comfortable doing whatever it took to win. So, in the two cases that come to mind, my most recent cases with her, she was turning over discovery in a specially set murder case the day before we were picking a jury, and the jury only took a day to pick. It wasn't like a Young Thug case. She flipped a witness by making, though not an actual deal with him about his open charges, but kind of talking generally, like, we can probably help you, keeping it right on that line of what's inappropriate, to flip him against my client and change all of his testimony the day before court. She actually brought up Young Thug during that trial in 2017. My client, they said, was a blood because he had he looked a little bit like Jeffrey Williams. So they said that he was basically like imitating Young Thug, who was a blood, and that all came in during that trial. Anyways, Adrienne did what it took to, she plays dirty. She knows it. So then we had, Daniel and I had another case with her that resulted in 2 jury trials, 2 week-long experiences with her, where it's just very, very clear to both of us that she will hit below the belt, and she'll do it because she knows that there is no accountability for her, that there will be no punishment, and that it will not affect the outcome of the case. So, accusing witnesses of perjury instead of just attacking their credibility with actual evidence, just taking it to an extreme, and her ability to discern, what's really criminal and what she should get worked up and angry about. It just kind of seems as though she's an open opportunity. Whatever case is in front of her, she will do whatever it takes to vilify the defendant, make the victim seem more innocent, and do whatever it takes to try and win. We saw that in opening statement in the Young Thug case. It's hard for us to watch because our client that we had those 2 trials with actually passed away in the Fulton County Jail, waiting for
his third trial
in the case, and I blame her. So it's hard for me to see her objectively, and I recognize that. But I also feel like very, very quickly in her opening statement, it became clear that she was going to do the same thing again, and then pretend like, oops, I had no idea. So she gets up and says, as she's standing there and talking about gangs, and she says, there will be no evidence that these 6 defendants did not do the things that we are accusing them of. Bruce Harvey objects. He says...
Very competent lawyer. Glad he's in the case.
Our favorite. And he says, that's burden shifting, Your Honor.
And he cites the case.
The judge who has handled many jury trials knew immediately. Obviously, that is burden shifting, and he sustained the objection. I believe there was a limiting instruction provided later. I just want to talk about that. Adrienne Love has tried,
loads.
Dozens of jury trial cases. She knows very well that the burden is solely on the state. She knows that. Yet somehow...
Well, it's the presumption of innocence. That's what you're talking about. And she's shifting that.
She's saying that if there's no evidence that they did not, that somehow she wins.
Mm-hmm. It's inappropriate.
It's completely inappropriate, and it's just...
A seasoned lawyer would never say it, and she said it. But there's more.
And she said it confidently. Okay.
Yeah.
Then she starts putting up her PowerPoint, and there's objections from the defense. And the defense is saying, we never saw this. They clear out the jurors, and I think it took another hour and a half, because Adrienne Love did not follow the court's instructions, and she did not turn over. She said that she thought she only had to turn over the photographs that she was planning on using in opening, but not the wording that she was going to put on a PowerPoint to present to the jurors. Within these PowerPoint slides, not only are there errors in it.
There's factual errors.
There's factual errors, and by factual errors, I mean the judge had said, you can't talk about these things. Well, there's that. So there's, you cannot talk about these things.
Certain
Do
things
not
are
put it in
inadmissible.
there. Yeah, these things are inadmissible. Somehow they're just inadvertently there. or facts that are completely irrelevant, like the fact that I think Young Thug's one of his attorneys represents somebody else in YSL that she mentioned, and in her PowerPoint she mentions that person too is represented by Brian Steele.
That person was convicted of murder and is up on appeal, and Brian Steele's the attorney. Completely inappropriate.
I mean, she knows that she wasn't supposed to put that in there, and she's like, "Oops." And so everything has to stop. Adrian has to send all these six defendants the PowerPoint so that their attorneys, when they're supposed to be preparing for their own opening statements, have to stop what they're doing to make sure that Adrian isn't going to ring a bell in front of the jury that can't be unrung. Here's the issue. This case took this long, 11 months, to get a jury seated. Adrian and the defendants know at this point that he's not going to grant a mistrial unless the behavior is like flagrantly problematic and can't be undone. Adrian, fully aware of this, knows that the judge is not going to mistry the case because she puts up inappropriate, factually incorrect or correct but inadmissible information.
And prejudicial information.
So she just says, "Oops, I'm sorry." And each of the defendants are saying, look on slide 34. You shouldn't have this there. And she's like, "Oh, Judge, I'll change that right now." You were about to do all of that in front of the jury. And anyways, the judge didn't get as mad at her as I felt like he should have. Mostly because he knows. Everybody else knows. This is not the first time that she does something like this. Nobody else knows that, like the viewers, but we know that she's just used to taking a few hits like that. She's like, "Oh, well," and she just keeps going.
And the hits will keep coming.
Now, she'll keep doing this.
Just for the sake of clarity, Jeffrey Williams' lawyer did move for a mistrial. Well, first of all, Bruce Harvey objected correctly to
the burden shifting.
To the burden shifting. Brian Steele moved for a mistrial to perfect the record. Brian knows what he's doing. He's perfecting the record for appeal.
He had the slide put in as a piece of evidence as well.
He had the slide marked as an exhibit. And the court, as Rachel said, Adrian knows this, the court's not going to declare a mistrial. The court's going to seek to get this trial to a verdict. And then there's a whole different standard on appeal, which Adrian Love is very much aware of, and that is that the appellate court seeks to affirm the trial jury's verdict.
So
they seek to affirm. Yeah. So she can do this.
She can cross the line a few times, just not too hard. Yeah.
She can do this with knowledge that the court spent 10 months getting a jury in there, get a jury seated, that the court will not declare the mistrial, and that the appellate court will look at this much more forgiving because the appellate court does not seek to reverse the trial jury's verdict. She knows it. We all know it. And she does it anyway.
Okay. Just something else that I kind of noticed so she talked for a really long time. She got back up in front of the jurors after Brian Steele had his motion for mistrial outside of the presence of the jury. She stood back up and said just a few more moments to the jury, except she took another hour, which I think is really perfect for her. Keep lying to the jurors, keep kind of missing. Let's just see what happens. So she starts telling them about this agreement, this concept for the purposes of a RICO. So for racketeering, there has to be this conspiracy, and she does this in other cases too, where she knows that it's not that this is not a typical racketeering case. This is not a racketeering case where there's going to be, like financial books where they're going to be able to say that he took out this money.
Written agreements. And
she starts just basically saying, I don't need any of those things. Evidence isn't going to show those things, but arguing that's still a conspiracy, that's still RICO, arguing they don't act like a typical gang, but they're still a gang. So that's happening, and then she sits down. And I'm like, enough already. The jurors at that point must have just been banging their heads against the wall because she starts trying to go into the individual defendants. And it's just, by that point...
There's too much data.
By that point, I was exhausted listening to her. The other thing with her is that there's a lot of, anger inside of her. She read some of the lyrics. She used some of the lyrics from some of the songs.
That's the whole First Amendment issue.
That's the whole First Amendment issue, but, she was going hard. I'm sure they were... you're not doing it well, Adrian. But one of the songs is take this shit to motherfucking trial. And, she was reading out what they said in the song. I guess it's powerful. It sounds like it's coming from her, and she sounds like she's just as mad as anybody else who'd be saying
and
it.
it's back to the mud theory. Just throw mud on the wall. Just keep throwing it on the wall. The crater, the animals.
She's
the
all
wolves,
the things that to me, she's all the things that she accuses them of. But, so lastly, so she sits down, and I think the first
defendants then give their opening statement.
So the order that it goes in, we have no idea how they decided that, but I believe Brian Steele went first.
Yeah, Brian went first, and talk a little bit about Brian's opening statement.
Maybe he didn't go first. I feel like he did.
I don't know if he did or
know.
not.
I can't remember. So he got up there, and he's an academic. He's a scholar. He does a lot of appellate work, so he knows the law.
And he's a very competent lawyer.
Very competent lawyer. I felt like he laid out he laid everything out. It just was taking so long to get the words out, and I think he was trying to be very intentional in the words that came out of his mouth. That the cadence, the pace of his opening kind of lost me. I could listen to it for 5 minutes, and I'm not sure what I just heard.
And this is following Adrian Love's very long, kind of disassociated opening statement. So here comes Brian giving his outline of the case, and it was
competent.
good.
It's competent.
It was competent. How about that?
It was competent.
Do you want to go into Jay?
Yeah. So I'm looking for. So we watched that. Okay, he's done.
So put yourself in the position of a juror sitting in this chair after several interruptions, and you've got to listen to these lawyers. So you're trying to pay attention, and even some of the names are difficult to comprehend, let alone the conduct.
Given that there's how many 100 and something acts that
184.
184 acts. So it all kind of got mumbled jumbled. I think that Brian Steele did a good job of laying out what he's going to do, but if you were tired after listening to Adrian, that did not wake you up. Brian Steele's opening didn't really wake me up. Then there were, I think, a few other attorneys that went. Oh, actually, who went first was Max Shard, and he went the first day. And I thought he did a really good job. His whole thing is the murder case against his clients based on a jailhouse informant, not necessarily he is an informant. He got locked up and wanted to call the police and try to find a way out by telling on other people. So that
works.
Yeah. So and he's like, other than that, there's no other evidence. Like, okay, that's going to be fun. So he did a good job. Brian Steele did a good job, but again, I'm bored. I'm kind of bored. There was another female attorney. She spent a little too much time, in my opinion, talking about how being poor and where they're from. Didn't
make much sense.
Well,
but compliment her for doing it. They may have a lot of evidence against her client, and I don't remember his name, but it was, again, not what an opening statement is supposed to be.
No, she was talking about him being born on the floor.
Born on the couch and economic depravity, but that's not the evidence. He's accused of a crime. What do you have to show that he is guilty or not guilty? That's the opening statement.
I felt like we were in a different presentation.
We're in a different world on that one. Now,
Jay,
go to your Rodney Dangerfield with a legal degree.
It's okay. So, I'm watching, and we know these lawyers, so I'm excited to kind of see what
you've actually tried a case.
I've tried a case with Jay in front of Judge Glanville.
So, talk a little bit about Jay. What's his full name? And
Jay Apt. I believe he's representing Mr. Kendrick.
He's accused of killing Donovan Mitchell. Is that his name?
No, I think Donovan Mitchell's a basketball player.
Yeah, Donovan. I'll tell you who
something
it is.
Donovan or something. Either it doesn't matter. Jay Apt.
Donovan is a basketball player.
Yeah. So Jay Apt gets up there, and for the first time since openings began,
Donovan Thomas.
I find myself looking up like,
what
this is about to get funny. So this is a big case. This is a media case. People are watching, but it's boring, and it's been boring during jury selection this whole time. Jay Apt gets up there like a real character, like a real trial lawyer, bringing the heat, bringing the fun, bringing the drama.
A lot of constitutional discussion, which really isn't appropriate for opening statement, but he rips into due process and presumption of innocence, First Amendment, freedom of speech.
Yeah, there's certain things that he said that really, he was presenting to the jurors, because I think we all forget that sometimes, is that an opening statement, we've gone over the evidence so many times. We know the case, we know the story, and we kind of forget that we're telling these people the story for the first time, and that we want them to remember what we say. So we have to distinguish ourselves. we have to do it in a way that works for us. Like I can't get up there and do what Jay did because that's not how I do it.
It's not how you
But
roll.
I cannot. I appreciate everything that he did, and I know that at least some of the jurors were laughing inside or smirking because even if he's ridiculous and some of him, he's saying it's beautiful music. Some of the lyrics of Young Thug songs are pretty outrageous. But he says it's beautiful music.
Well, he's the mumbling rapper, they call him.
Yeah, well, you'd be better off not actually printing the lyrics and just letting him mumble, and then we would never understand what he was saying.
So one of the things that we did as Rachel and I were watching these opening statements was we were reviewing the commentary that the viewers were putting in on YouTube. And it was hilarious because the viewers on YouTube could be your jurors. These are just regular people without legal degrees and legal educations and courtroom training. So they're basically seeing this through the eyes of the jurors, and they were loving Jay Ott.
Yeah, they were having fun. Finally,
they were having fun. They woke up. They called him Brian Steele on Adderall.
They called him a lot of things that were really funny. Shining like his head, and because he's bald.
That he's going to be in the new Young Thug lyrics. They're going to cover his.
They're going to get him a chain.
They're going to get him a chain, a YSL chain. But the point
he
being,
turned up.
He turned up. He talked about a lot of things that had nothing really to do with opening statement, heavily on the Constitution, on due process and freedom of speech. And then he did go into the evidence on the homicide, the murder of Donovan Thomas. And I thought it was very effective. Now you're into the facts. And he's saying, and I'm not sure if this is accurate, but he's saying the evidence will not show any fingerprints, any eyewitnesses, any firearms associated with his client and the death of Donovan Thomas. That was persuasive to me. So with
the car that was used, with the guns that were used, no one's going to put him there. And if that's true.
If it's true. He also said, now again, this is the purpose of opening statement. He's on the rails now. He's doing what he's supposed to do. He's also saying the cops arrested a group before they arrested my client and charged them with the murder. And then the guy they charged with the murder said, it wasn't me, it was Jay's client. And he said, how much credibility can you give that guy?
And they dismissed those cases against them, and yet my client's still standing here.
So as animated as Jay was, and how, I guess...
He used the word, the Krispy Kreme donut hole. I mean, he was very descriptive and almost comical.
And emotional. He was turned up like Rodney Dangerfield on the Johnny Carson show. He was going after it. And again, a lot of it was just out there, was not like...
But it's something that a juror could hang on to. I mean, whether or not that they think that that these jurors think that free speech should be able to be used against somebody is not for them to decide. However, it could affect their decision.
Yeah, so let me explain this. This is an interesting point. In these multiple defendant cases, as a trial lawyer, you have one of two strategies. Do I want to fade away? Do I want to sit farthest away from the jury? Do I want to not bring any attention to me? So in the end, the lawyer can argue they don't have any evidence against him. You don't even know who he is. You only heard his name once or twice. That's not proof beyond a reasonable doubt. Therefore, you must cut him loose. Jay took the complete opposite approach, which I think is strategically fascinating, because they're going to remember Jay, and they're going to remember his client, and they're going to remember Donovan Thomas, which incidentally was one of the heart of the government's decision to prosecute YSL, because it was a big deal killing down here on McDaniel Street in the city of Atlanta. But they're going to remember what this lawyer, this bald-headed lawyer...
What he told them.
And if Jay was right, he set the stage. He put the props up for arguing in the end, look what I told you in opening statement. They didn't have any of the evidence that I told you they wouldn't have. Therefore,
he's not guilty.
He's not guilty, and you must acquit him.
Even if they have some other things that could circumstantially put...
Which they
probably will. But I love that Jay was like, well, if these aren't... I mean, how do you find somebody guilty without those things? How do you find somebody guilty without those things? We have a presumption of innocence for a reason. Oh, one of the other things that his client has already been sentenced and has already served his time, I guess, on some of the related things predicate acts. So the predicate acts that they're going to bring up about him to explain that he was part of this conspiracy and part of this racketeering agreement. They're going to bring up things that he's already pled guilty to and done his time for.
So stop. So this is accurate. This defendant, I can't remember his name. Kendrick, is that his name? Kendrick. Mm-hmm. He somewhere between 2010 and 2020, 2015 or 2020, he pled guilty to several violations. He went to prison for those violations. So he either pled guilty or was found guilty. He did his time. He was released. Now, the Fulton County District Attorney's Office has chosen to make those acts predicate acts for the RICO count. And what's interesting, you would think, and I thought, well, jeopardy attaches here. He's already been prosecuted for this. But the legal authority, the case law in Georgia says that even though you've been found guilty of these predicate acts, because an additional factor is necessary to prove you of guilty, that being RICO, they can be used against him. So it's counterintuitive, but it's legal. Now, Jay argued it's just improper.
It's immoral.
Immoral,
it's
and you can't do it. But Jay also knows that it's legal to do it.
But I love that he argued that because jurors are coming from a moral perspective. He's already done his time on that. Why are we looking back to something that he's already been punished for and trying to punish him again? As jurors, I understand they're not supposed to consider these things, but you want to put that in their head if you can.
And he did it.
If you can. I mean, is it proper? If she objected, if Adrian objected, it's very possible that they would have sustained it. But I felt that was really good. I want jurors talking about. You want jurors in the back talking about the First Amendment. He wants jurors in the back talking about how shitty it is.
He didn't use the word double jeopardy, but that's what he was arguing.
Yeah, he's saying, why should you be able? I mean, and it's true. You shouldn't be punished the rest of your life for mistakes that you've made and that you've paid for. And humans are the only species that does that. I read that somewhere. I was like, it's true. I mean, you can't keep punishing him unless he's done something new, which he says that they haven't. So all I know is that throughout this trial, now that Jay he was like a teacher that was really enthusiastic about whatever he's teaching you.
I like your Rodney Dangerfield analogy.
Yeah, well, it's like some teachers are boring, and you're just kind of like, okay, like I'm sleeping.
My client can't get no respect. That's what he was arguing. And again, he's planted the thought in the juror's mind, and I remember specifically having to look this up when it first happened in Georgia. How can you prosecute this kid for a crime when he's already been found guilty and done his time? Now, Jay knows that you can do that.
But should you?
But he put it in the juror's head, and they're going to think this doesn't make any sense.
And they should argue
and
that in the back.
Are they persecuting his client? So it was very clever and very well done, and his delivery was excellent.
His delivery was excellent because it would be like going into you just slept through first and second period.
Yeah, you
third
slept
period,
through, right.
And then you just have this teacher that you can't help but look away because you don't want to look away because he's just everything that's coming out of his mouth and it's funny.
What in God's name is this guy doing?
Yeah, I mean,
what's he saying?
But he is the lawyer that you imagine to be on TV. He's giving them the courtroom experience. I mean, yeah, he's giving them the shtick. He's what you would expect out of a trial attorney. Yeah. He's just all the way out there.
And he had the good look, too, the suit with the haircut and
he's
all that
a character,
jazz.
and he will be that person throughout the whole trial. And I now know that because they'll look forward to going to fourth period with him, is what I'm saying. When it's his turn to talk now,
they'll pay attention because he'll keep the energy there, but also they had that kind of, he was the only one, in my opinion, that kind of took like a human approach to the evidence in front of the jury. Not like apologizing for where they came from, not yelling at the jurors about how there's, violence and all this stuff. He's just being like a Krispy Kreme donut hole. It was just perfect. I mean, he was saying it's like, shiny on the outside, and there's just like a hole of air on the inside. Yeah, it was clever.
Yeah, and those are the kind of, they're going to think about him. They're going to think about Krispy Kreme. They're going to think his head's shiny. They're going to think of it. And they're going to keep that with them as they go forward through this long, long trial. And if jurors like you, they're more likely to accept what you say as true and go with you. And so that's true. That's the reason that what he did, in my opinion, was so persuasive to me. Because I woke up, because I was watching him, I'm like, I can't keep these names straight. We've got 6 defendants, and then we've got victims, and then we've got all these other acts against other people. I'm like, I don't really understand how jurors are going to be able to keep any of this straight. That was at the end of the day.
Again, it's the mud on the wall.
And then we should say, I don't believe that Bruce Harvey made an opening statement on behalf of his client, and it appears...
As of yet,
it appears that he possibly maybe
Waiving and reserving.
Waiving and reserving, which means that he waits until the state finishes their presentation of the case, and then he gets to speak to jurors. It's a very interesting strategic move because, again,
Clever.
Because they're going in front. The defendants are going right after Adrian spent like 4 hours just like yelling at them and telling them about the jungle and wolves and how bad all these people are, all of that. And it's like going on a tour to a bunch of different cathedrals. The first one might be special, and then you just kind of like, okay. There's like a diminishing reward.
It's me in an art museum.
Diminishing reward. After a few minutes, you're just like, okay. So,
nice piece.
So
nice
Bruce getting to pop up in the middle after the state's had all those witnesses and just actually directly look the jurors in the eye and start there. Have a minute. Great. Have a few minutes with them that nobody else is going to get. Mm-hmm.
It'll have persuasive value.
Yeah.
So let's talk a little bit about constitutional law here. The big one is First Amendment, the lyrics of an artist being used as evidence. But before we talk about that, I just wanted to cover the due process, because you heard several of the lawyers talking about the presumption of innocence, which is a due process right, and proof beyond a reasonable doubt. So it's a criminal case. The defendants are presumed innocent, and the government must prove them guilty beyond a reasonable doubt. The defendants have absolutely no responsibility to put up any evidence to prove or show their innocence. Now, one of the issues that's become publicly and legally debated in this case is the use of musical lyrics, artistic renditions, as evidence in a criminal case. And I believe California has prohibited it, but Georgia has not. Georgia has found it admissible, and at least Judge Glanville has said it's admissible in this trial. And what it is, I guess specifically in this case, is you have a rapper named Young Thug, Jeffrey Williams, who is accused of writing lyrics that are incriminating. They're like declarations against penal interest. They are admissions of wrongdoing, and he did them lyrically. So the government moved to have them admitted into evidence, the lyrics into evidence, the published recordings into evidence, the copyrighted material into evidence as examples or declarations or statements of incriminating behavior. So, what do you have to say about that? Are you in agreement with that use, or is it an artistic violation, or should it be protected free speech and not allowed into evidence?
Okay, so as an attorney, as a counselor, if I had been Young Thug's manager or attorney, then I would tell him absolutely not to do that. Don't publish the actual lyrics, number one.
There's a concept called clearing a record in the music industry.
I didn't know
somebody was supposed to clear those records.
I would have cleared it.
You would have said no. You would have said you got to strike this out.
Yeah, I would have cleared it after he fixes it, but I'm not clearing. Somebody needed to be in charge of that. However, I was just thinking as we're sitting here that it was what happened. So if he's rapping about things that have happened, not about things that are going to happen.
Right.
So I think that's really...
Filling up a Tahoe with bullets.
I think that's true. I mean, if you know that happened, you're telling the story that happened. You're not saying you did that.
Or your gang members did it. So first of all, do you find that it's admissible evidence?
I don't find...
It's relevant?
I do think it's admissible because I think... Like anything else, it's your statement. If you put your name on it and you state it and you publish it in any way.
Should it be privileged speech that should not be? Okay.
I don't think so. I don't know why it would be privileged versus anything else. Like if I don't know, John Grisham wrote a book and then it was about like his wife getting killed in a very specific way, and then and then his wife ended up dead that way. They could absolutely bring that book in against him. I think that there is a lot of room for argument that Young Thug wasn't making money off of this gang, YSL, whatever crimes they were doing. He was making money off telling the story from this gang's perspective.
I think that's fabulous.
And I think that it's kind of like...
Yeah, it's true. I published this. I sang it.
And I knew it happened.
But I'm in the streets. And
I'm
a child of the streets.
Even if you claim it after it happened, that doesn't mean that you committed that crime.
Or that you encouraged it.
Or that you encouraged it.
So that's up to his lawyers, and we'll see how strategic they are, whether they follow Rachel's lead on this, because it's been deemed admissible by the judge. It's coming in, and it's more than one lyrical verse. There's several of them. There's the one about the Chevy Tahoe getting filled with bullets. There's somebody's mother's home got shot up, and there's others. But what Rachel says is, can you strategically say, okay, I sing about a lot of things, and some of the issues that I discuss are criminal, but it doesn't mean that I am the criminal or that someone acted criminally on my behalf.
Yeah,
it's just of the streets.
Yeah, it kind of reminds me of like a team. Okay, so not to bring up the Gaza-Israel thing, but if somebody does something and then you cheer them on after the fact, you are not guilty of doing that thing. You may support that thing in your having had it happen. I also think all this comes down to fear. Is that all these kids? It's so sad. The fact that they were poor, the way that they grew up, is relevant to the type of language that they use that would offend the average person. The fact that these kids grew up watching people shoot each other, get shot. That's how conflicts were resolved. That's the kind of music that people want to hear. That's the kind of world that they're living in. That's what they see. That's what they see people doing. Take that shit to trial. When he says that, he has lived in a community since he was a baby, since all of them were babies, where people are either taking it to trial or they're pleading out.
Yeah.
And these people that have died as the result of whatever gang war or whatever they're saying happened, let's just say that's true. If it is a gang war, you have to understand that people are scared. So if they're scared of being attacked, then they're going to take credit for things that have happened to be like, do that to me, I'll do that right back to you. And so I think that I don't like any of it.
But it's a different world.
And it doesn't mean that because you said, yeah, this happened, like you want to come screw with us, this is what you're going to get.
Or I'm tired of copping pleas. I'm going to take it to trial and I'm going to make a song about it. And that's their world. It's a small world.
It's a world that they understand.
Lyrically unique. It's a world they understand.
Yeah, like the people, that song in not in maybe the communities that most people are in, but in the worlds that we live in, that song hits. That song makes sense. That song is it talks about, it's the issue of whether to take it to trial. And if you don't get an offer, like a probation offer to RICO, you're going to have to take that shit to trial. So it's like, yeah, I have to pump, and before trial, you're going to pretend like, I shouldn't go to trial. Though you have to pump yourself up and you have to take it to trial, like JF. You go all the way. So I understand that I can make excuses for that, because I do think...
Well, you can explain it. It's not an excuse. It's an explanation. And it's legitimate.
Doesn't make it criminal.
So let's hope that I guess that would be Jeffrey Williams' attorney, follows Rachel's advice here and her lead and explains it from a musician and every songwriter writes about his world, and they can just explain this as music of the culture.
Lyrical museum. These are things that are happening. It's a historical. Yeah. I'm not saying it's great, but that's not what the jurors are being asked to decide. And to say that because when he's rapping about it, he's not committing crimes doing it. And
listen, Neil Young wrote a song called "4 Dead in Ohio." That doesn't mean he shot kids.
I shot the sheriff.
And Eric Clapton did Bob Marley's "I Shot the Sheriff." Doesn't mean that they shot the sheriff or that they shot people on the college campus. It's just
if someone that they're friends with or their family member shot the sheriff, that still shouldn't mean that they shot the sheriff.
Right.
That person who lyrically.
So this is a great constitutional issue and a great constitutional argument, and I really hope that the lawyers or the lawyer who is confronted with this, and I think it's mostly Thug's attorney, will follow or Rachel's advice in how to handle it, because it is First Amendment and it is a country where we honor and cherish freedom of expression, and this is an expression of life, an expression of culture, an expression of music by the artist.
I had another thought as we're sitting here, that what if there was a ghostwriter?
Could be. Well,
ghostwriters are common. I'm just saying those are common things that like artists don't like to tell people, that people help them write their shit. But
I just saw that on the Hall & Oates controversy, by the way. I thought they authored all their music.
And there's ghostwriters. That's what I'm saying. So you want to, even though he signs his name to it, you want to attribute everything that went into that. I mean, when you're winning from it, it's good.
When you're getting the royalties.
Yeah, but it's like you didn't write that, and
so we'll see what he does with it.
That would be an interesting thing if you got on the stand and was like, I actually didn't. Yeah. Like I took credit for songs that I actually didn't write.
Yeah, that's another defense. Okay, so anything else you want to cover today?
No, I just want everyone to watch out for the below the belt hits from Adrian. They're coming.
So remember that opening statements are not evidence. That's critical. It's just somebody's opinion.
That's why she gets away with it. It's not a mistrial.
That's right, and it's an opinion of what the facts and facts at trial will show. So just remember that, because we're wrapping up the opening statements. It's not evidence. A lot of it was like way outside the box on both sides, but we were forewarning you to watch out for Adrian Love, because this will not be an isolated incident. I can feel confident that you're going to see conduct on her behalf that is questionable throughout the trial.
Yeah, I won't say some of the most hilarious comments that were being written about her during the live streaming of her thing, but other people seem to agree with us. So.
Well, we've been reserved about our commentary about the prosecution also, so we're trying to keep it above the belt.
It's hard when people fight below the belt, but that's what all these lawyers also have to do, is not meet her down in the trenches, because it'll make them look just as bad.
That's right.
Till next.
Okay.
Till next time.
The Law Project is here. We're happy to be back, and we'll keep you up to date on the trial of the State of Georgia versus Jeffrey Williams et al. And thank you.